Please don't lose them.
You want me to put it in the car for you, Miss Odum?
There's a block now.
Okay. Well, I mean, it's going to be secured in Branning's yard. I mean, that's no problem. All right. Come right back here, all right? And I'll make sure you don't get ran over.
A 52-year-old grandmother gets pulled over for a flickering brake light. She's calm, she's cooperative. She even lets the deputy search her car. No warrant, no argument, no hesitation. And 30 minutes later, she's in handcuffs, charged with felony methamphetamine possession. Here's the thing. The drugs weren't hers. The deputy put them there, on camera, while she stood on the side of the road. And what makes this case so important, what makes it one of the most alarming constitutional violations in recent memory, is not just what this officer did, it's how close the system came to letting it work. Today we are breaking down the full case of Teresa Odum versus Deputy Zack Wester, and we are going through every single constitutional issue, layer by layer, the way the law actually sees it. Stay with me, because by the end of this video, you are going to understand your rights in a way most Americans never do. February 15, 2018, Marianna, Florida, about 4 o'clock in the afternoon. Deputy Zack Wester of the Jackson County Sheriff's Office pulls over a woman named Teresa Odum. She's 52 years old, she's a grandmother, and at the time of this stop, she is on felony probation for a prior charge of dealing in stolen property. Deputy Wester's stated reason for the stop? Her brake lights were flickering on and off. Now let's start right here, because even before anything else happens, we need to ask, was this stop even constitutional? Under the Fourth Amendment to the United States Constitution, a traffic stop is a seizure. That is not a matter of debate. The Supreme Court confirmed this in Delaware v. Prowse in 1979, and because a stop is a seizure, it requires, at minimum, reasonable suspicion. Reasonable suspicion means a specific, articulable, objective basis to believe that a traffic law was violated or that criminal activity is taking place. A malfunctioning brake light is a legitimate equipment violation under Florida law. So on paper, yes, Deputy Wester had the legal authority to initiate that stop. But here is where things start to unravel, because the moment that stop begins, the clock starts, and the Constitution puts very strict limits on what an officer can do and for how long once you were pulled over. Those limits are about to become extremely important. Deputy Wester takes her license, runs it, comes back, and here is what he says. He tells her there is a canine unit on the way. A drug dog is going to walk around her vehicle. But instead of waiting for that, he asks if she will just consent to a search right now. She says yes. And I want to pause here, because this is the most important moment in this entire video. This is the moment that changes everything. When Teresa Odum said, yes, go ahead, she waived one of the most powerful protections the Constitution gives her. The Fourth Amendment protects every American from unreasonable searches and seizures. That means that without a warrant, without probable cause, without your permission, the police generally cannot search your car. But the Supreme Court made clear in Schneckloth v. Bustamante in 1973 that this protection can be voluntarily surrendered. The moment you give consent, that's it. The officer needs nothing else. No warrant, no probable cause, no reasonable suspicion. Zero. You said yes, and that yes is legally binding. So why did Deputy Wester even ask? Why not just wait for the dog? Because he likely couldn't. In 2015, the Supreme Court decided one of the most important traffic stop cases in modern history, Rodriguez versus United States. And what the court said was this: extending a traffic stop beyond the time reasonably necessary to deal with the original violation, even by just a few minutes to wait for a drug-sniffing dog, violates the Fourth Amendment unless there is independent, reasonable suspicion of criminal activity. Wester had none. He had a flickering brake light, nothing more. His options were let her go or get her permission. He asked, she said yes, and that one moment of cooperation, that one act of good faith toward a deputy who did not deserve it, opened the door to everything that followed. Now, here is what I need you to hear. You have the absolute right to say no. Politely, calmly, without aggression, without explanation, you simply say, "Officer, I do not consent to a search." That is not an admission of guilt, that is not being difficult, that is exercising a right that the founders wrote into the Bill of Rights specifically for moments exactly like this one. If an officer asks for your permission to search, 9 times out of 10 it is because they do not have the legal authority to search without it. Remember that. Here is where this case becomes something else entirely. Deputy Wester begins his search of Teresa Odum's vehicle, and body camera footage that Wester apparently forgot was still recording, captures something that would eventually end his career and send him to prison. Before putting on his gloves, Wester is seen holding what appears to be a small plastic bag. That bag was later proven to contain methamphetamine. He put it in her car. And when he finds it, the same bag he carried in, he confronts her about it, reads her Miranda rights, and places her under arrest for felony drug possession. Now, there is no single statute in Florida that uses the exact phrase planting evidence, but what Wester did violated multiple laws simultaneously, and it obliterated the Constitution at every level. Under Florida Statute 838.022, official misconduct, it is a felony for a public servant to knowingly falsify any official record to cause unlawful harm to another person. The moment Wester wrote a police report describing those drugs as something he discovered in her car, he committed this crime. Under Florida Statute 918.13, fabricating evidence, knowingly presenting false physical evidence in a pending investigation is a felony. Presenting drugs you planted as real evidence found at a scene is the textbook definition of this offense. And beyond state law, look at what this does to the Constitution. The 14th Amendment guarantees that no state shall deprive any person of life, liberty, or property without due process of law. That guarantee is not abstract. It means the government cannot lock you in a cage based on evidence it manufactured. It means the process itself, the investigation, the arrest, the prosecution, must be grounded in truth. Framing someone with planted evidence doesn't bend due process, it destroys it completely. Federal courts have consistently held under 42 U.S.C. Section 1983 that the deliberate fabrication of evidence by a law enforcement officer violates clearly established constitutional rights and exposes that officer to both criminal prosecution and civil liability. What Wester did was not aggressive policing. It was not a gray area. It was not a judgment call. It was a crime committed by a man with a badge against an innocent woman on the side of a Florida highway. After planting the drugs, Wester conducts a roadside chemical field test. He comes back with a result, presumptive positive for methamphetamine. And Teresa Odum, standing on the side of the road watching this happen, hears the word positive and knows that most people watching will hear that word and think, case closed. But here is what that word actually means in the world of forensic science. Field drug tests are unreliable, profoundly, dangerously unreliable. The Florida Department of Law Enforcement's own data shows that approximately 21% of substances submitted to state labs as methamphetamine were not methamphetamine. Half of those false positives weren't even controlled substances, not illegal at all. In just the first 7 months of 2014, Hillsborough County alone reported 15 false meth positives from a single sheriff's office after deputies misread which color indicated a positive result. One of the most common cocaine field tests uses a chemical called cobalt thiocyanate. That chemical turns blue when exposed to cocaine. It also turns blue with more than 80 other chemical compounds, including over-the-counter acne medications, common household cleaners, and methadone. Temperature affects results, lighting affects results, humidity affects results. The experience level of the officer reading the test affects results. And here is the critical legal point. Because of all this unreliability, field drug tests are inadmissible as evidence in court. They cannot be used to convict you. Courts do not allow it. And yet, when more than 90% of criminal cases in the United States are resolved through plea bargains, prosecutors accept guilty pleas based on field drug test results every single day, before any lab testing is conducted, before any independent verification of the substance ever happens. A person gets arrested, they sit in a jail cell, they don't have money for bail. Their court-appointed attorney tells them the district attorney is offering a deal: plead no contest, serve less time, go home. The alternative is sitting in jail for months waiting for a trial with a felony hanging over them. Most people, especially people without financial resources, take the deal. Teresa Odum did exactly that. She pled no contest. She spent 19 days in jail for a crime she did not commit, carrying drugs she had never seen, arrested by an officer who swore an oath to protect her and then used that oath as a weapon against her. The Fourth Amendment did not fail her. The 14th Amendment did not fail her. The law, on paper, was on her side the entire time. The human beings charged with upholding that law failed her. But here is what I want you to carry from this video. She fought back. She pursued the proper legal channels, and eventually, imperfectly, slowly, the system corrected itself. Know your rights. Exercise them without apology. And if they are ever violated, hold every responsible person accountable to the fullest extent the law allows.
If this video helped you understand something you didn't before, share it. Because the best thing that comes from a case like this is that fewer people get caught off guard the next time. Subscribe if you haven't already, drop your questions in the comments, and I'll see you in the next one.